An update as to SB 30 and HB 4806. SB 30 has passed in the Senate and has been submitted to the House for consideration. Those of you who are memory challenged like I am, following two babies, at least is the case for me. If you do not remember how a bill is enacted into law, the bill is written, submitted, voted, and then presented to the opposite for consideration. The opposite being the Senate presents the bill, the House would be the one presented. And here's a brief resuscitation of that. SB 30 has passed committee, Senate vote, Senate floor, and has been presented to the House committee. Simultaneously, HB 4806 would see the same happen if it reaches the House floor and be presented by the Senate committee, which it has not yet. To revisit the 10-part series on why it is bad for our community, there is an area of the Senate Bill 30 and House Bill 4806 that addresses disclosures, mandatory now for providers, healthcare providers. You'll see it here in the section. Let's do. If the individual was referred to a provider for services and the provider will provide testimony that presented to the trier of fact. And there's the search term referral. Now, out in the community, you may not think, and my clients struggle with this a lot during their depositions. Oh, my attorney referred me. My attorney sent me to this medical provider. Imagine the context if you are in trial and a jury of 12 people who do not know you, maybe they've never been presented with the circumstance of having to file a claim, and they hear that an attorney is referring clients over to care or a multitude of providers for care. The goal of the insurance company and the defense lawyers in these circumstances is to manipulate the context of that statement, referral. Traditionally, in the referral sense, medical providers send a referral out for maybe diagnostic imaging, an MRI, or referral out to a specialist, ear, nose, and throat. In the personal injury context, personal injury lawyers help facilitate appointments for our clients as a kind of residual responsibility for what we are hired to do, which is to help an individual who has experienced a harm or loss following an injury producing event. That would include potentially communicating with healthcare providers. And if the healthcare provider is willing to treat and examine and create a treatment plan and diagnose this patient, then ultimately the coordination of that appointment is something that personal injury lawyers will help facilitate. We do not refer patients to specific providers. The treatment plan in of itself is under the umbrella of a medical provider. Attorneys are not medical doctors. We do not diagnose injured people. We do not, although we are familiar with the biology and the medical behind a diagnosis, in and of itself, the term referral is not contextually applicable. However, Senate Bill 30 and HB 4806 would make it to where the provider must disclose if we have in some way provided the client with information about that particular facility as an option for them to treat at. Potentially client chooses that facility, and the facility then would have to disclose that the attorneys are referring that patient over. Very rarely are the clients doing their own independent research and choosing a facility because it's not broadcast to the community. These are facilities that will treat following a motor vehicle collision under what's called a letter of protection, which simply means they will hold the balance. They will still charge for those services, but they will hold the balance until resolution from either the insurance carrier or the responsible party themselves. Insurance companies want to manipulate juries into believing that a lawyer drives up the cost for care, drives up the treatment plan. They don't want the jury to actually believe that the person is injured, but that the attorney has fabricated those injuries. That is what Senate Bill 30 and House Bill 4806 is trying to do within this particular provision. It is completely taking it out of context. I have not seen it actually play out well for them in trial. In fact, I have not seen a judge permit, as of yet, in all of the trials that I have had, permit a defense lawyer in talking to a jury that plaintiff lawyers typically refer their patients or clients out to patient care. But I'm not sure whether that strategy will then change or those rulings will change following SB 30 and House Bill 4806 implementation of the disclosures. If it's discoverable now based on this language, very likely will change rulings for a court simply by referencing the fact that the law now permits by statute the referral to be disclosed by the provider. Activate, contact your legislature. There are several platforms, but use Google if you need to figure out how to communicate that this is not in Texas's best interest. If you want information on how to track the bill, I would register with Fast Track. It is a website that I have registered for purposes of tracking SB 30, and here it is, Fast Democracy, and I have registered for tracking SB 30 and House Bill 4806. So thanks.